Mochi Health is here to help you start your weight loss journey with caring, personalized support. Meet one-on-one with board-certified obesity doctors and registered dietitians who truly listen and understand your unique needs. Eligible patients can access affordable GLP-1 medications delivered right to their door each month. No insurance? No problem. Mochi Health accepts FSA and HSA, making care accessible and affordable. And with 24/7 customer service, you'll never feel alone on your path to better health. Get started with Mochi Health today. Take the free quiz at joinmochi.com and use code AUDIO40 at checkout for $40 off your first month of membership. That's joinmochi.com with promo code AUDIO40.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my healthful co-host, Brett.
I wish I could say the same for you, Alice. I hate to be the helpful one in the duo.
It's true. If it sounds like our voices are different, it's because I think my voice is a whole octave lower because I'm a little bit sick. But you know what? Before you hit that 1-star review and say, man, they sound sick, just think, I could literally be in bed instead of recording. But we have a lot to talk about today because I was much too sick to record yesterday when the verdict came down in the Jennifer Crumbley case, but I pulled myself out of bed today because 24 hours later is better than never. Those of you who've been watching the week-long trial of Michigan school shooter Ethan Crumbley's mother, Jennifer Crumbley, were in for kind of bombshell news yesterday, and a lot of people have asked, is this a slippery slope? And that question is, her son took a gun and killed 4 students, injured many others at his school. And she, as the mother, was charged with 4 counts of involuntary manslaughter. How far does that go in holding parents accountable for the actions of their minor children? And what does this mean going forward for other kinds of charges that could be brought against school shooters' parents, or really any parents of any minors who commit really terrible acts such as this one?
No, it's a question we get asked a lot, and I think it's a great question, and I can understand why people are both curious and to some extent concerned about it. I know some people are very afraid that this is a slippery slope. For those of you who did not follow the case, I think a lot of people follow this one pretty closely. As Alice said, Jennifer Crumbley is the mother of Ethan Crumbley. You may recall back in 2021, he went into his high school and shot and killed 4 students and wounded several others in Michigan. Now, he was 15 at the time, but he was tried as an adult for the crime and sentenced to life without parole, plus 24 years. So he's not getting out unless there's some significant change, which is just an interesting discussion in of itself. You have a 15-year-old who receives a life without parole sentence, and just to make sure, an additional 24 years. That is an interesting discussion. We've had discussions about minors before and how you deal with them. Not what we're talking about today. We're talking about the other side of this case, and that's whether or not his parents can be held legally responsible for his actions. Jennifer was charged with 4 counts of involuntary manslaughter, 1 for each of the students who died that day. And the prosecution's theory of the case was that Jennifer, she is criminally responsible for the crime, even though she is not the one to pull the trigger. And these cases are always controversial because there's always a sense of, if you're not the person who did it, if you're not the one who killed someone, maybe we should hold you responsible for something, but should we hold you responsible for murder or manslaughter? You see this with felony murder cases. And that's why these often are complicated, number one, difficult. I mean, these cases are tough. A regular murder case, it's easy to wrap your head around. You just decide whether or not they did it. If they did, they're guilty. You can move forward. This one has a lot more sort of philosophical, moral, legal questions that you really have to grapple with.
Yeah, absolutely. And as in every case, you can't think about this in the abstract. This is very fact specific. And also, as in every single trial, the jury is given instructions by the judge to lay out the legal standard that they need to find in order to find Jennifer, in this case, guilty. So the jury instructions laid out what is necessary to find her guilty, and it consists of two possible theories of guilt. We talk about this a lot, especially in this case. It's kind of an interesting, difficult, complex case. It's not unusual to charge with kind of two different theories. So one theory is a failure to perform a legal duty. And in order to find her guilty, the jury had to find that Jennifer Crumbley had a legal duty to the victims killed in the shooting. In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child so as to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. This duty arises when both of the following are true. 1, the parent knows or has reason to know that they have the ability to control their minor child. And 2, the parent knows of the necessity and opportunity for exercising such control. Second, the defendant must have known the facts that gave rise to the duty. Third, the defendant willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And lastly, to find her guilty, the death of the victims were directly caused by Jennifer Crumbley's failure to perform this duty. That is, the victims died as a result of Crumbley's failure to exercise reasonable care to control her minor child, to prevent him from intentionally harming others, or conducting himself to create an unreasonable risk of bodily harm to others when Crumbley knew she had the ability to control her son and knew of the necessity and opportunity to do so. So that's one theory.
And by the way, these are the jury instructions. So this is what the jury was read. And jury instructions are interesting because if you're sitting out there thinking that's confusing, they're not supposed to be. They're supposed to be how the judge explains to an ordinary person with no legal education what they're supposed to do back there in the jury room. They're supposed to take these instructions, apply the facts that have been given to them, and then determine whether or not they fit in either one of these sort of ways of thinking about this. And we're about to go over the second way they could find her guilty. And one thing that's interesting to note, if you're a juror, if you believe either one of those, you can vote guilty. So you might have 6 people who think it's one and 6 people who think it's the other, and they're all voting guilty. And you can do that because it's still one statute, still one crime. If you had a situation where 6 people could vote guilty on one crime and 6 people could vote guilty on a different one, and that gets you to guilty, that's actually a problem. You can get your conviction overturned because of that. That is not the situation here. This is just 2 different ways of thinking about the same statute and whether or not she violated that statute or not, and attempting to apply these facts to the statute. So that's the legal duty version. And just to give you sort of an example, I mean, this is obviously couched in terms of minor child and everything else because it's written for a jury who's making a decision about this minor child. I think one example that happens sort of more commonly might be a bar. So if you have a bar and you're selling alcohol, you have certain legal duties about the people who go to your bar. You don't have to police everybody that's in the bar. You don't have to, you're not in control of them. But if you do have someone who is very, very, very drunk, very obviously drunk, and you continue to serve them and they continue to get more and more drunk, and you are observing the fact that they are getting more and more drunk, and at some point, they leave and maybe get in a car and drive away, and you knew they were getting into a car, you made no attempt to stop them, and oh, by the way, you overserved them. That's a situation where you could imagine some sort of charge against you because you had a legal duty, you ignored it, you contributed to the problem, and now someone's dead. That's also controversial, right? Because of all the reasons we just talked about. How much of a responsibility do you have for an adult out there doing what adults can do? But we have decided that certain people do have these legal obligations. If you're going to sort of put yourself in a certain position, you have a legal obligation. Another example, lifeguards. If you're a lifeguard and you set yourself up as somebody who's going to go out and save people, you actually have a duty to attempt to save people in a lot of states. So if you're a lifeguard, you're sitting on the beach, you see somebody struggling, and you're like, and it's not like a red flag situation, just a normal day, and they're out there and they're struggling, and you're like, I'm not going to go out there. If you don't do that, you can be held criminally responsible for that because you have a legal duty because of your position. And, ordinarily, you don't have a duty to save someone. If you're just an ordinary person and you see somebody drowning, you don't have to go try and save them. If you're a lifeguard, you do. So this is a legal construct that we use to encourage people to do the things that we feel as though they should be legally obligated to do. In this case, control your child when you know your child is a danger. So that's the first one, legal duty. The second one is a gross negligence theory. We've heard a lot about gross negligence in the Delphi case. This is applicable to involuntary manslaughter, and honestly is probably the more common thing that you see when you see involuntary manslaughter. Usually it's something like this. So gross negligence, it's more than just carelessness. Negligence typically is carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you must find each of the following three things beyond a reasonable doubt. 1, Crumbley knew of the danger to another. That is, she knew that there was a situation that required her to take ordinary care to avoid injuring another. 2, Crumbley could have avoided injuring another by using ordinary care. And 3, Crumbley failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be a serious injury. And just an example you might think of with this, reckless driving. So imagine you're driving recklessly down the road. You know that the way you're driving is potentially dangerous. You know that it's something that could injure another person, but you fail to exercise the ordinary care that you should be exercising as someone who's driving a car. You lose control, you hit somebody, they die. That's a situation in which your gross negligence in operating your vehicle might result in a charge of involuntary manslaughter.
And note with the gross negligence standard, what Brett just read you again, this was read to the jury, it's not about taking extraordinary care, but over and over, the standard that's within the gross negligence standard is ordinary care. So nothing extraordinary about it, but trying to basically go at the baseline. That's why it's gross negligence, because any person looking at the situation would say, yeah, you got to take him home that day. Or, yeah, you got to lock up that gun when he's drawing pictures of guns that day. So note that, those of you who may be thinking, oh my goodness, this is a landslide. Listen to the actual standard. And now that we know the standards, let's look at the evidence that came out during trial. Those of you who watched, it was about a week long, and Jennifer Crumbley also took the stand, which we can talk about how the jury may respond to her. I thought she did not do herself any favors, obviously, when she took the stand in her affect and in a lot of things that she said that we'll talk about in the evidence. And a lot of it is undisputed. That's what makes this case, I think, pretty special. This was not a wildly factually disputed case. In fact, the day of the shooting, I think most of the facts are undisputed. I think Jennifer may disagree with interpretations, but what actually happened that day is undisputed. So let's look at the evidence that came out during trial. First, Jennifer ignored her son's mental issues. In spring of 2021, and the shooting happened in November of 2021, so 6 months before the shooting, Crumbley sent his mother text messages explaining that there was a ghost or devil in the house and begged her to respond to him, but she didn't. When he told his parents he was having hallucinations and asked for help, she laughed at him. Now, in her testimony, Crumbley said that the first was a joke and the second didn't happen. Whatever it is, you can tell that by her own testimony, it's undisputed that her son sent text messages that said, help me, and said, I'm having hallucinations. And she did not seek help for him. Or in the text messages, appear to speak to him about them, right? I think everyone has different thoughts about what care they want to give their kids, but this was not a situation where he asked for help and she said, well, let's try these different avenues first. From these text messages and from what came out in her testimony, it doesn't appear that she tried any avenues to try and address these concerns that he raised to her. Second, a few months later in November, she purchased the firearm, a 9mm Sig Sauer SP semi-automatic handgun. Now, she took her son out to the gun range that day when she purchased the gun, and she said she did not lock the gun up because that was her husband's responsibility. So on the stand, she very much put her hands out and was like, not my responsibility, although she is the one to purchase the gun and also use the gun with her son. So there was no indication that she didn't know how to lock up the gun.
Yeah. And look, I think one thing that's important as we go through these facts and go through this evidence is involuntary manslaughter. Like we said, it's complicated, it's confusing, and it can be controversial, but it's not new. It's been around for forever. This is not really about the law. It's not really about what the law says. It's about whether or not the factual situation reaches the level necessary for involuntary manslaughter. And there was a lot of stuff that was talked about in this trial that, frankly, I thought didn't really matter. There was a lot of sort of side drama and circus stuff and defense attorneys acting badly and lots of, prejudicial information coming in. But really the facts that are important here are these things that relate directly to what she knew, when she knew it, and what she did with the knowledge. So she knows or should have known. And that's what's always important. Knows or should have known are always the thing, because, you can't, if you're foolishly ignorant, you can still be held responsible. So she knows that her son is telling her he's having these hallucinations. He's having mental issues. He's begging her for help. He's saying that he's seeing things that aren't there. She ignores him. He tells his parents he's having hallucinations. He asks for help. She laughs at him. This is in spring of 2021, only a few months before this shooting. Rather than doing anything to help him, what she does is she goes out and she buys him a gun. Now remember, he's 15 years old. I think in some states, maybe most states, if you're under 18, you cannot purchase a handgun. Now, a gun can be purchased for you. I guess in this situation it's one of them, but you can't purchase one. They go out and purchase this gun for him. They then take him out to the range, or she takes him out to the range, shows him how to use this gun. So now she knows he has mental problems and he's armed and he knows how to use the weapon. And she knows that because she provided the gun and taught him how to do it. How the gun was available to him, I don't know, but she certainly didn't take any steps to make sure it would not be available to him. It gets even worse, though, because I don't necessarily know that that's enough. If that's all you had, I don't think you get there. Maybe you would, but I don't think you would. But on the day of the shooting, a teacher finds a drawing that Ethan has made showing him with a gun and a person bleeding on the ground. Written on the bottom was, "The thoughts won't stop. Help me. Blood everywhere, and my life is useless." At this point, the parents are called to the school, and the counselor recommends that they take him home and they get him into immediate mental health treatment. They decline to do so because they don't want to miss work. So they leave him in the school. But despite the drawing, despite the warning, despite the seeming confirmation of all the mental health issues he's had up to that point, they do not tell the school that they just purchased a gun for Ethan. They leave that out. They also don't tell them that he's been hallucinating, and they don't tell the officials at the school that there is a previous history of mental health issues. To me, those are the four big facts, the four big pieces of evidence that you really have to decide on. Is that enough to meet the standard either under that first theory of involuntary manslaughter or the second one?
And a lot of other things come out, of course. But, I think the last kind of fact that Brett put out there really sets this case factually apart from a lot of cases that you may see or you may be worried about where parents are charged for the actions of their minor children in mass murder cases. And this is such a textbook clean evidence case, right? Typically, it's like we missed the signs leading up to it. Here you have a situation where the actual day of the shooting, you have her son essentially saying what he is struggling with. He doesn't want to do it, but he has a picture of a gun and my life is useless. And the thoughts won't stop. Help me. If there's dispute about what he texted her previously, this was a help me. And they showed this picture. It was like his geometry homework or something that he was doodling on. And they texted this picture to his parents or at least to his mother, and his mother shared it with his dad. And they had a meeting that day. They had the opportunity to act on this information and they didn't. Again, I say this because I don't know that there's ever been this is a very, very clean, direct line of what happened that day. It's hard when you have hindsight 2020, when it's like, if only I saw the signs 6 months earlier. And that's why I think what Brett said is very meaningful here. If it were just the text messages about hallucinations back in spring of 2021, 6 months before all of this, I could imagine it being a much tougher case, because it's like, well, he was kind of he was a jokester. He always joked about these sorts of things. There's no evidence that he did, by the way, but it's so far, it's somewhat far removed from the actual shooting. How could I possibly have seen this? Whereas when you have the fact of something happening the day of and the school raising alarm bells and affirmatively asking the parents to take him out of school and they turn it down, that is, and again, when Jennifer took the stand, she didn't really do herself any favors. My understanding was her testimony said that her boss was fine with her taking the day off work. This wasn't a situation where she's living paycheck to paycheck, and if she didn't show back up to work within 30 minutes of that meeting, she was going to lose her job, or that she was in some job that required her to be back right away. Maybe she was, whatever it was, she was irreplaceable. That wasn't the situation. Now, being a parent, I understand not wanting to miss work, but this did not help her when it appeared on the stand that she could have taken the day off, and she chose not to. And of course, what we know happened is absolutely devastating. And of course, the kind of clip that's been just making the rounds online is when asked if she would change anything, she said no. Here's the thing. Again, hindsight 2020, you can't say no because you know what happened. 4 people died. Many more kids and adults were injured. People's lives were changed forever. Your answer can't be, no, I wouldn't change anything. It could be, I didn't know enough then to change it, but I can't imagine that sat well with the jury.
Yeah, and a couple things I'll point out just in response to some things that were said by the defense and some people have mentioned in the chat. The defense, basically, one of the things they said was, look, the school should have taken more action. They're just as responsible. The first thing is, it doesn't actually matter. It doesn't actually matter if somebody else is also responsible. They're going to try his father as well, and we'll see whether or not he's convicted. And the fact that his mother was convicted doesn't mean he can't be convicted. Maybe the school is responsible. Doesn't mean she's not. If in her position, she knew enough and she acted in a way and she could have stopped it and she didn't, she can be responsible and somebody else can as well. The other thing, the school, when you talk about the school's responsibility, it's classic hindsight's 2020. It's the kind of things that frankly shouldn't lead you to be convicted of involuntary manslaughter. It's, we should have seen the signs and we should have done this and we should have taken more action and we should have been more firm and we should have, right? The thing is, the school, when they looked at that picture and they saw the drawing of a gun, they didn't know, well, he probably knew how to draw a gun because we just gave him one. He has a gun. Looks just like that. We just bought it for him. In fact, we took it out and shot the gun recently. The parents did not tell the school that. That is a critical piece of information that's missing. If the parents had told the school that and the school had not taken any action, I think it would be very different for both of them. Number one, I think the parents would have a much better argument for why they are not responsible, and the school would probably have a much worse argument for why they are not responsible. It's a sort of complex set of facts you have to apply to the different actors that you're trying to assign blame to.
Yeah, and I think the holder of the information that he did have this gun, that he did have access to, not being shared in the midst of this meeting with the school is a really bad fact against Jennifer and her husband, who is also charged with 4 counts of manslaughter and will be on trial in March. Now, one thing to note, there were a lot of witnesses, but one person who did not testify was the minor child, Ethan Crumbley himself. He did not testify, and he cited his right to not incriminate himself. Now, this is an interesting question because you can plead the Fifth if you have concern about being prosecuted. We already know that he he's already been convicted and he's already been sentenced. So what did that mean? And, would it have been any better if Ethan had testified for Jennifer? I will say, especially with all the 404B information coming in about Jennifer's extracurricular activities in her social life, a lot of people came away with the impression that Ethan was let down as a child by his parents. And he, so I don't know that this would have helped necessarily.
Yeah, and I'll say two things about that. The first thing is, legally, because Ethan's appeals have not expired, he can still appeal his sentence, for instance, even though he pleaded guilty. He can still plead the fifth. Basically, the rule as it's developed, it used to be once sentencing was complete, you could not plead the fifth. But then states, more and more states, I don't think the United States Supreme Court's ever said this, but a lot of states have said it. I'm sure Michigan's in this camp, that the prejudice that can go to you if you're in the course of appealing, it still applies. It can apply to your sentence. If you're sent back for resentencing and you've been forced to testify and you said all sorts of terrible things, that can be used against you at your sentencing. So therefore, if you're in appeal, you can't be forced to testify against yourself. So that's where he is on that. And that, it makes sense. I think the other thing that's important is Ethan, he was let down, and that's a reason to charge or to hold someone else accountable, people who let him down, possibly, depending on the other facts. It is not necessarily a reason that he shouldn't be convicted. He is not unlike many, 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 many murderers. In fact, this is often something you see, particularly at sentencing, mitigation evidence of a terrible childhood, of parents who didn't care, of parents who were physically and sexually abusive, all sorts of really horrible things. And those are things you can take into account when you're thinking about the person who's in front of you and the sentence they should receive. But it doesn't necessarily mean that, he's not guilty, for instance. It's not a defense to the crime. It's just something that you can take into account when you're thinking about this stuff. Would his testimony have been helpful for her? Probably not. I mean, I guess if he had gotten on the stand and said, look, you've heard all this stuff, I never really told her that, or always acted like I was joking, like Alice said. They were great parents. They did everything for me. I broke into the safe to get the gun out. That's how I got it. Like, there are things he probably could have said that would have been helpful. I doubt he would have said any of those things. I think the facts here, as Alice said, are pretty clear. I mean, it's just a pretty clear case where you have a situation where you have a parent who knows that their child is dangerous, gives them a weapon. They basically, he did not go to her and say, hey, I'm going to shoot up the school today. But what he wrote and what he drew was as close to that as it could be without him saying it, without him just coming out and saying it. Presumably, if he had gone to her that morning and said, hey, Mom, hope you have a great day at work. I'm going to go shoot up the school. Thanks for the gun, right? Everybody would agree, okay, in that circumstance, she probably has some responsibility. Here, you have her sitting in that room, holding that piece of paper, seeing what she's seeing, knowing what she knows, and doing nothing to stop it. And the question is she criminally liable for that? Is she criminally liable for the fact that her 15-year-old then went and shot up the school? And I have no problem with the jury's determination. People can go different ways on it. You can weigh those facts in different ways. To me, the fact that she was eventually convicted of these 4 counts and all 4 counts, it's just not a problem. And I don't think it's a slippery slope because I think it is so fact bound. It is not as if we did not have involuntary manslaughter until this case. It's not as if this is the case that established that we can prosecute people for involuntary manslaughter. We could do that at any time. And I think you're going to need facts like this that are very clear, that really point to sort of a but-for causation type thing in order to bring these kind of charges in the future. So I'm not as worried about a slippery slope as some people are. For instance, it's not as if you can go down to a jury in some other state and say, well, you should convict because up in Michigan, they had this case and they convicted her. Now, will it embolden prosecutors? Sure. Because whenever you see a theory of the law that is tested out and successfully used, a lot of times you'll see other people go for that as well. And think about that when in other situations where this sort of thing is going on.
Yeah, I think the jury could have come out either way. I'm not particularly surprised the way they came out because of the things we said, the kind of undisputed facts, the day of the shooting facts that really are undisputed. I mean, there's a picture that he doodled of what looks like, to most people, a bullet hole in a person. And on the stand, she said, "Oh, I thought it was Batman with a cape." You didn't even see really any sort of sadness, it seemed, at what was happening. So I can understand why this very clear-cut fact pattern led to this verdict. And note that the two theories that we read out to you guys, gross negligence and failure to perform a legal duty, this is really important. This existed well before this particular case. And so this, these laws were not written to fit this particular case. And that's what we always do. We try to see if the facts fit the particular law in place. And in this instance, I think the jury had enough to vote to convict. Now, of course, look, I understand the concern that people do have because there are always thoughts of, I can't imagine my child would ever do that. Or what's the best way to parent? Where is the line between the government or criminal law impinging on my kind of freedom as a parent to decide how best to treat a child? Because, there certainly could be arguments to be made that maybe he did very poorly when he was taken out of school, that he needed to be in a more structured environment. But again, this particular situation, even Jennifer said herself, we'd never seen something like this. This was out of the ordinary. It's not like he doodled these types of things all the time. It's not like he drew pictures of guns all the time. And she didn't mention the gun. So I agree. I don't think it's a slippery slope per se, but I do think it will make a lot of parents maybe nervous about what their parenting decisions may implicate for the future. Because we don't know how every decision you make as a parent will ultimately pan out. You hope you're not raising someone who becomes a mass shooter. Absolutely. Now, I think based on all the 404B evidence that came out, there were probably a lot of shortcomings with Jennifer's raising of her son, which we can talk about whether all of that was really appropriate before the jury. But it did all come in. And so it was something that they got to hear and consider. But I just want to acknowledge that I recognize where the fear of the slippery slope comes from. And, for example, when I prosecuted doctor cases, bad doctor cases, doctors who were outside of their lane of lawful prescribing, I was very cognizant that I didn't want to have a chilling effect on good doctors for doing their job well, recognizing that the law was not supposed to control the medical field, right? Like, I don't have an expertise in the medical field. And there's always a concern. And we talked about this in our Redonda Vaught nurse case, that there's always a fear whenever you prosecute these fringe cases, there's a potential chilling effect. But in this particular case, I just think the facts line up so well that the verdict does stand here. And one other thing, I was having this conversation with a friend just today about how the law exists, and prosecutions exist, really, for these fringe cases. We're not supposed to be governed by prosecutions, right? Like, if we depended on no murders based on prosecution of murder cases, we're all going to be dead. Everyone's going to be murdered, right? That's just not how our legal system is built. The legal system is not meant to solve every single one of our problems. And it's really interesting when you have the legal system, criminal law, kind of butting up against something that's very fundamental in terms of personal and privacy, and that's parenting freedom and parenting judgment as well. So I think that law and prosecutions really only should be applied to those fringe cases. And this, I think, is one of those fringe cases. Each fact that came out in the trial was just a little bit more and more egregious. And the total lack of kind of remorse was a little bit shocking. And I think that affected the jury as well. And look,
maybe I'm an extremist on this. I just don't have any pity for someone who shirks all their responsibility. And I think she shirked all her responsibility, both as a parent and as a gun owner. And ain't nobody out there bigger on guns than I am. Okay, y'all know that. I'm on record about this. I talk about guns a lot. I own guns. I've owned guns for a long time, since I was younger than Ethan Crumbley. And I don't think there's anything wrong with that. I don't think there's anything wrong with teaching your kids about guns. But I think when you own a gun, it is not just a right that you have in this country. is also a massive responsibility. You have a responsibility. When you choose to purchase a firearm, you take on that responsibility. You also have a responsibility when you have kids. And I don't think this is something you're going to see happen all the time. I don't think you're going to see it happen in every or even most school shooter cases. But when you see people who take no responsibility as parents and take no responsibility as gun owners, and then their children take a gun and shoot someone, yeah, I think you can prosecute that person. And if you have the facts, I have no problem with the jury convicting them. And that's just the way I see this case. I think they had the facts. The law was on their side, and I never doubted that they were going to be convicted. I was surprised people were surprised.
I will say this. I think it'll be a very different evidentiary case if there were other measures taken, if they had disclosed that there was a gun, even if they didn't take him out that day and said, you know what, I think if we take him out, I think he's really going to self-harm. Can we do a suicide protocol at school? I know that that's something that you guys are trained in doing. I don't know how to do this at home. Can you help us manage this? You know, if they had gotten him help, if they had told him about the gun, if they had secured the gun, if they had checked on the gun after they had this meeting to see where it was, if he had access to it, to check him. You know, I think those were not facts that occurred in this case. So I think the totality of the facts here made it one of those fringe cases that resulted in a guilty verdict.
And I think that's such a great way of putting it, because if it would have taken extraordinary parenting, Herculean parenting, ordinary parenting to stop this from happening, I don't think you have a conviction. It took almost nothing. It took the bare minimum of what you would expect from a parent to stop this from happening. And she didn't take any of those steps. And I think that's important. And I think that's an important reason why this is different. This is not, you know, you buy your kid a car and they're not a very good driver, and you know that, and you're trying to teach them, but man, they're terrible. And then they get in a car wreck and kill 4 people. This is not that case. This is a far more egregious case than that. It's not even a case where you own a gun and your child, who you have no reason to suspect is having these thoughts, takes the gun and goes to school and shoots some people. It is so mumuch worse than either one of those examples.
And that's a really great point. Another way to think about this is oftentimes in these situations, the parents don't know the whole situation, right? They suddenly have access to the kid's phone and they're like, I had no idea he was having these thoughts. I didn't know he had access to my gun. I didn't know he was doing X, Y, and Z. It was undisputed that they knew the whole story. They knew more than the school in this situation. And that's why this case is pushed into the fringe. There was nothing on the stand. She was like, yeah, I found that out after the fact. No, they knew everything. They gave the gun to him. They knew he could shoot it. There's video of them going to the gun range together. And so this is just not a situation where they didn't know the whole story. They knew more than anyone else. And therefore, because they knew more than anyone else, they were in a position to do something.
And when you think about sort of your mental state, you know, mens rea, right? Like the way you're thinking about these things, ordinarily, I think it's probably unfair to hold someone accountable when they say, well, I really wouldn't have changed anything because who knows, and you can't live your life in regret. But the fact that she knew all those things then, this happened, and she's still willing to say, nah, wouldn't have done anything different, I think was really, really bad for her. If I had been a juror, if I'd had any doubt, that would have been where all doubt left my mind, and I would have said, yeah, guilty.
That's basically it. It wasn't that difficult of a trial. There's a lot of stuff that happened during trial that is, you know, it was all televised. You can watch it if you'd like. But hopefully this explains to you the legal standard that the jury had to find the facts to match up to and what it was based on and why we don't think that this is going to be a particularly slippery slope. Of course, whenever a highly televised, highly covered, publicized case like this results in a conviction of the parent who did not pull the trigger, it's going to have some chilling effect somewhere, right? But you know what? I'm kind of okay with that chilling effect if it means more parents maybe take them out of school that day and prevent a couple shootings. Like that's a kind of a chilling effect I'm okay with. And, you know, we'll see how other cases pan out here, but I don't actually think that this is going to result in, you know, a slew of prosecutions against parents who are trying their best and maybe didn't do the thing that helped them. Who knows if these steps would have prevented their son from causing major harm to people. But I think based on the evidence that came out in trial, they could have prevented that day. And that's what this trial was about. Those 4 people who were killed that day within hours of the meeting.
And her defense attorney was terrible.
It was,
She also had that going against her.
It was really, really bad. I looked at her profile and I was like, this doesn't compute. Like, you should be better.
There are people who think it was an intentional strategy, which maybe it was, I don't know, to make the jury dislike her and maybe feel sorry for her client. And maybe, I don't know. Possible. It was not good. I watched the closing arguments and I was like, wow, that's not how I would choose to do a closing argument. Yeah.
But you know.
I mean, it's not like she didn't have an argument to make. It's the argument all of us have been having. I mean, there is an effective argument here for why she can't be responsible for this or shouldn't be responsible for this, but it just didn't really feel like it was made. Now, as we always say, it will not be ineffective assistance of counsel because that's not the kind of thing that'll get you that. But, well, look, I mean, I'm really interested to hear what you guys think. This has been very controversial in the chat. A lot of people have very strong feelings about it. Totally get that. We love when you guys have strong feelings. We love hearing your thoughts. We love hearing all your different views on this. And this was a controversial case. A lot of you guys live in other countries and you just think this is wild because you don't even have guns. Here in the United States, we have more guns than we have people. So, you know, this is something that we have to grapple with. And it was controversial politically just because people who were very pro-gun, people who were very anti-gun, they had strong feelings on this for reasons that really had nothing to do with the case or the law or the facts. And totally get that. But I think if you just step back and you take a look at the law and you take a look at the facts, you can see how they line up. And honestly, it's kind of like the Redonda Vaught case. You know, we totally agreed with the way that ended up being handled, that she was found guilty, but then not sentenced to anything. Now, I think Jennifer Crumbley will be sentenced to something and should be. But sometimes you just have a law and you have facts, and it's so clear that the person violated the law that they should be convicted. And if you're going to sort of fix it, you can fix it on the back end with sentencing. And I think there is some similarity there, except Redonda Vaught was a far more sympathetic character than Jennifer Crumbley, who managed to come off just as poorly as she possibly could. And I think some of that probably was her attorney. But
well, I made it through the episode.
You did.
I know there's probably a lot more to talk about, and we can always follow up with that. But I'm proud of myself for making through this episode.
You did great, Alice. And we managed to make it through this entire episode without mentioning the fact that you're never going to get a case dismissed based on accidental deletion of a video that
happens all the time, by the way.
Might be important.
Exculpatory.
Yeah.
And even if it did, if there's no willful deleting, obviously we're talking about Delphi and the motion to dismiss that was filed. Don't worry, guys. That happens all the time because we don't know how to work electronics to this day.
The number of times we have body cam footage that records the entire crime and everything critical to the case that accidentally gets deleted, and we still were able to move forward, and the defense is like, we totally would be innocent if only we had this video.
Yep.
And they just make that argument to the jury.
You want to know why, though? It's because everything's recorded all the time, and it literally takes a lot of, footage, and there's not enough, storage space for all of these police departments to be able to store everything forever. And so usually they all auto record over each other because most of what you have is not important. You have to record every single thing you do, and you have to actively not auto record over past tapes. And if you forget to do it, which you sometimes do, that's what happens. So unless you can show willful, yeah, we're definitely not discussing it. But unless you can show it's willful, there's no, they say it's willful, but they have no evidence that it is. But anyways, we said we wouldn't talk about Delphi.
And we didn't.
And we didn't. Yeah, exactly. Do we have questions we want to answer today?
Are you up for questions?
Yeah, I will do some questions. I will even do ads today. We're going to do this. And then I'm going to go drink tea in bed.
Okay. That sounds good. I hear whiskey's good for the for the cough.
That will definitely knock me out, but might slow my heart rate so much that it would be dangerous.
Legal briefs questions. Okay, this is from PDrink10. Have you ever thought of or worked on an investigation end such as FBI or other investigative agency? Or have you wanted to but missed the opportunity? I tell you what, I think when I was growing up, the idea of working for the FBI, it just seemed so awesome. And there were times where I thought I wanted to do that. And then I worked with the FBI. And the thing about the FBI, they spend so much time on paperwork. Like, it would just drive me crazy. There's so much paperwork.
So much red tape with that
So
agency.
much red tape.
Like, it is not, I mean, look, God bless my friends in the FBI, but I've never met an agency, which says a lot, that has that much paperwork.
It's so much.
So, like, if you want to fight crime, you want to be a beat cop for, like, a local jurisdiction.
Still a lot of paperwork, but nowhere near as much as the FBI.
But you, like, get to see stuff. The FBI is, like, so much paperwork. No, that's like, yeah, we do stuff like that all the time. And there are some really good agents, and it's really great working with them. But, man, the paperwork. Which, by the way, when we talk about all of this, like spoliation and like, it didn't say that in that report, guys, the amount of paperwork they have to do is just insane. And there is human error in some of it. And also you can't possibly like write verbatim everything that happens, especially because most interviews are not recorded, especially when it's like you're just trying to canvas the landscape.
Yeah, and that's the other thing. When you do a recorded interview and there's also a report that says what was in the interview, the fact that the interview got deleted is even less important than it should be. Okay, one last question, and then Alice is going to bed. Okay, let's see. This is from Viper Wolf.
Ooh,
have you ever played pickleball?
I have not yet, but I'm so excited for when I have time again because I hear it's easier on our old bodies than tennis. And I think tennis has passed me by, but I'm very excited to join the pickleball league in our neighborhood.
See, I want to play it too. I really liked racquetball.
You want to play together?
We should totally play together.
We should totally.
I love racquetball.
We should do that.
When I was in college, I played racquetball all the time. And then when I went to Harvard, they played squash. And squash is terrible. Racquetball is so much more fun.
I
feel
would
like
get hit in the face with
like
squash balls all the time. Because like you have to heat up the ball. Like, what does that even mean? What heat up the ball? What is this? It's an inanimate object.
It's an inferior racket sport is what it is.
But I'm very excited about pickleball because I feel like whenever I get emails from my neighborhood pickleball, they're always like hilarious. Like no one seems to be taking themselves seriously, and that's my sport.
There you go.
They're like, dress up as your favorite animal day. I'm like, what? Okay.
Exactly. That's a sport I can play.
That's right.
All right. Well, that's all I got.
Well, thank you guys for always writing in with great questions. We'd love to hear from you. Reach out to us at prosecutorspod@gmail.com. You can also reach us on social media at prosecutorspod on Instagram, X, Twitter, Facebook, and we are now on TikTok.
We are. And if you follow our TikTok, we had a TikTok on the Jennifer Crumbley case. So you could have known our 50-second take on this without having to listen to 50 minutes of it.
Look at us stepping into, I'm going to say the 20th century because we're pretty behind. But all to say is there's lots of ways to reach out to us. We really read it. We don't really have a crew. We're not that fancy. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Yeah, Joe, I agree. People complain about us being sick. I think it's the other way around. Thanks for recording when you're sick.
I know, seriously.
Like, are you kidding me? I'd rather be in bed right now, which I have been most all day, but I am upright today for you.
Yeah, the complaining is just never ends. So you just have to not worry about it. I mean, it's totally true. The best way to deal with complaints is just to ignore them. I would like to say you want to take, constructive criticism, but there's so little constructive criticism. The better way to do it is just to ignore it.
Yeah. If you're